You may begin.
All right, so we're live now.
Yes.
All right, welcome everyone. This is the January 12th meeting of the Sentencing Guidelines Commission. I'm Kelly Mitchell, I'm the chair. We are meeting both, we have a hybrid meeting going today. Both some of us are here in person and some folks are online. I'm going to ask Director Wrights to take the roll.
Roll call. Estrada.
Present.
Estrada present. Hansi.
Present.
Hansi present. Ibrahim.
Present.
Ibrahim present. Knutson.
Present.
Knutson present. Ladd.
Present.
Ladd present. Larkin.
Present.
Larkin present. Middlebrook.
Present.
Middlebrook present. Moore.
Present.
Moore present. Morath.
Present.
Morath present. Schnell. Schnell. Schnell absent. Chair Mitchell.
Present.
Chair Mitchell present. Madam Chair, there are 10 members present, 1 member absent.
Okay, so we have a quorum today. I just got a message from Commissioner Schnell that he's having trouble with the panelist password. Same issue we all had. All right, let's see. Sorry about that. Just want to make sure I got back to him. First item is approval of the draft meeting agenda. I would entertain a motion to approve the agenda.
So moved.
Commissioner Larkin makes that motion. Do we have a second?
I'll second it.
Commissioner Ladd, second. Mr. Director Wrights, please go ahead and read the roll for that.
To the Larkin, motion to approve the agenda. Estrada.
Yes.
Estrada, yes. Hansi.
Yes.
Hansi, yes. Ibrahim.
Yes.
Ibrahim, yes. Knutson.
Yes.
Knutson, yes. Ladd.
Yes.
Ladd, yes. Larkin.
Yes.
Larkin, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore.
Yes.
Moore, yes. Morath.
Yes.
Morath, yes. Schnell. Schnell. No response. Schnell. Chair Mitchell.
Yes.
Chair Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. Next item on the agenda is approval of the draft minutes from December 15th. You should have all received those about a week ago. I'll entertain a motion to approve. Commissioner Middlebrook is making that motion. Do we have a second? Commissioner Larkin, seconds.
Sorry, who made the motion, Madam Chair?
Middlebrook.
Middlebrook.
Is there any discussion on the motion? Oh, before we do that, I just want to recognize that Commissioner Schnell has joined us. Do you want to say hi so we can hear you?
Yep, you hear me?
Yeah, we can hear you.
Excellent.
Thanks.
Thank you.
All right, so we have an active motion on approval of the minutes. Director Wrights.
To the Middlebrook, motion to approve the December meeting minutes. Estrada.
Yes.
Estrada, yes. Hansi.
Yes.
Hansi, yes. Ibrahim.
Yes.
Ibrahim, yes. Knutson.
Yes.
Knutson, yes. Ladd.
Yes.
Ladd, yes. Larkin.
Yes.
Larkin, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore.
Yes.
Moore, yes. Morath.
Yes.
Morath, yes. Schnell.
Yeah.
Schnell, yes. Chair Mitchell.
Yes.
Yes.
Chair Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
With that, the motion is approved unanimously. Fourth item on the agenda is to review the public hearing record. That's over to you, Nate.
Thank you, Madam Chair. On Monday, November 14th, 2022, the notice of public hearing was published in the State Register, volume 47, number 20. By the following day, the contents of the proposed modifications were posted on the Commission's website, and an email notice of the public hearing was sent to persons who have signed up on the Commission's website to receive informational emails. No one was notified by U.S. mail because there are no longer members of the public on the U.S. mailing list. Pursuant to the notice, the public hearing was held on December 15th, 2022 in the Minnesota State Capitol Room G3 and by telephone and or electronically. 4 members of the public wished to and did testify. After the public hearing, the record remained open for 5 calendar days through December 20th to accept written comments. From the beginning of the public hearing notice period through the end of the public comment period, the commission received 11 written comments. The complete public hearing record, including a list of those who spoke at the hearing, a link to the video and audio of the hearing, and copies of the written comments, were provided to all commission members on December 22nd, 2022, were posted on the commission's website shortly thereafter, and are included in today's meeting materials. Madam Chair, the commission appears to have complied with all public notice and hearing requirements to permit it to take final action on the proposed modifications today.
All right, thank you. So the next item on the agenda is to accept or reject proposals to amend the sentencing guidelines. We had 3 particular items go to public hearing. They're listed on the agenda as A, B, and C. I think the cleanest way to go through them today is to take them one at a time. So the first item that we'll take up are changes to the calculation of the custody status point.
Madam Chair,
Commissioner Larkin.
so how's this going to work? What's our process? What do you anticipate?
Well, in order to talk about the custody status proposal, essentially we need a motion to put a particular proposal in front of us. Are we voting on the proposal that went to public hearing? I mean, the normal thing would be to vote on what went to public hearing, but there might be some other process. I just saw Commissioner Middlebrook raise his hand, and I'll come back to you. Commissioner Middlebrook.
So thank you, Madam Chair. Just out of curiosity, so we've got the basically what was sent out from the staff on the actual proposal that went to public hearing, and then is there 2 or 3 other versions where it incorporated some of the feedback from the public hearing, particularly on the dispositional departure, and also to clarify on the probation status. I guess my question maybe is going to Nate.
Madam Chair, I'd be happy to clarify.
Sure.
So we have 4 documents before you. One is labeled 4A and G, and that is the public hearing notice. And that contains the 3 different sections that are being considered. So relevant to the current agenda item A, so that part A within that document, 4A and G, that's titled Changes to the Calculation of the Custody Status Point. That's the proposal that the commission adopted in November, and that's the proposal that went to the public before the public hearing. That's the first document. The second document you have before you is titled 5A1, and that is a staff document that has 2 parts to it. The first part is describing the authority for the commission to deviate from that first document, whether or not the commission has the freedom and to what extent the commission has the freedom to revise the proposal that went before the public at the public hearing. And then the second part of 5A1 lays out a few different revisions, possible revisions that have not been proposed by a commission member, but were simply staff's way of saving you time. If it's something that you were interested in, they responded to some of the comments that, at least from my perspective, I heard at the public hearing. Those comments that I heard at the public hearing, one just had in general to do with they're complex and confusing. So we tried to streamline it in 5A1. And then the second comment had to do with the fact that this was particularly MACAC testified that using a prior mitigated dispositional departure in the calculation of a criminal history point would add a new layer of complexity that would be onerous I'm paraphrasing, but that would be onerous on probation officers throughout the state and could possibly introduce errors and disparities. So Appendix 1 of 5A1 is an attempt to redraft the modifications that have been proposed, to revise those modifications in such a way that it answered those two questions. Appendix 2 in 5A1 is also an attempt to do the same thing, but conforming more closely to existing guidelines language than the structure of the proposal, which may have been part of the problem with the complexity. So the thought was the commission may find either Appendix 1 or Appendix 2 simpler. I think that's really a matter of your preference. But both of those attempt to achieve the same policy, which is the same as the policy that was proposed in November, except taking out the prior mitigated dispositional departure as an element of criminal history score in response to MACAC's complaint. There's also an Appendix 3 that has to do with a definition that was brought up by a public defender who testified. Appendix 3 is really an alternative to Appendix 1 and 2. If you adopted Appendix 1 or 2, it wouldn't be necessary to adopt Appendix 3. So that's the second document, and it has 3 appendixes. Then you have the third document. The third document is a proposal from Judge Larkin that was submitted, was it last week?
Initially last week.
Yeah, and then the fourth document is an amended proposal from Judge Larkin that was submitted yesterday. So that's a summary of the meeting materials that pertain to this agenda.
Commissioner Larkin.
Thank you. I was the one who proposed what went to the public hearing. I think it's one of many solutions we could consider, and I was grateful for the comments that we heard. As to those comments, I hear what the probation officers are saying. It is an extra step. It could lead to mistakes. I don't think it's impossible, but I respect that it does add another opportunity to get things wrong in sentencing, which we don't want to do. As to the comment that it's ambiguous, I don't agree it's ambiguous. And although I appreciate staff suggesting a way to address that comment, I don't think we have ever distinguished between different types of custody status when associating the penalty. I think that would interject a lot of confusion to say, well, only if it's this form of custody status does this happen. So I would be opposed to doing that. All of that said, on what went to the public hearing, I have spent a lot of time since November thinking about, are there other ways to address this that would solve and meet everyone's concerns? Because I hear concerns about, we reduce this half point or full point to a half, so we don't have people cross the line and end up incarcerated who otherwise wouldn't. We don't want to be overly punitive if we don't have to. And we want to treat everybody the same as best we can. And as the chair has pointed out, there's a lot of levers in the guidelines, and we've talked about a lot of things. And there might be one day where somebody, myself included, says, yeah, that sounds like a great idea. And then you think about it overnight and you look at the grid and you see how it'll play out. And well, maybe it's not a great idea. Maybe it causes this problem or the other problem. So this is so complicated. And so I hate to come to the table with another suggestion, but that's what I'm going to do, because I think it's one that would satisfy a lot of concerns. And that's sort of the modified version of what I sent last week, which is what I sent yesterday. And it's simply a suggestion that we amend the guidelines to say that if a person has a 1/2 custody point, whether it's because they just have it, and whether they are no matter where they are in the grid, if you have a 1/2 custody point, the potential consequence for that custody status is up to a 3-month addition to the duration of your sentence. So no one crosses any lines. It would simply be a rule that if you're on custody status, the judge may or may not increase the duration of your sentence by 1, 2, or 3 months. So that's my proposal. And in thinking about this, I said, let's apply that same rule to people who are maxed out on points. Let's take the 1/2 point out of the waiver rule, because that rule says, well, you can't waive if you have this level current commitment offense, and those are the most serious ones. And I guess my thinking was, if a person is maxed out on the grid based just on their criminal history score, or their new offense is one of these 7, 8, 9, 10 offenses that you can't do a waiver, the stakes are so high. I mean, if a judge wants to give a break on the 3 months or not, do we really need to have like one rule for that offender, for that person, and another rule for everybody else who gets a 1/2 point? So I thought the simplest thing to do was to come up with one rule that simply says, if you have a 1/2 point for custody status, the judge may add up to 3 months to your sentence. Does not have to, may. Wrote it into the ranges by saying you can go 3 lower, 3 higher, and just try to essentially keep the rule the same as it is. And that's my proposal. I think it satisfies sort of the overwhelming public opinion. We've heard that just from a common sense, practical perspective, if you're on probation for a felony and you commit a new offense, there should be some recognition that the new offense is more serious. This rule allows that by allowing, not requiring the judge to add up to 3 months. It could be 1 month, 2 months, or 3 months. It also gives the judge discretion to look at the particular circumstances of individual cases, because even though the guidelines strive for, and we strive for, procedures that won't result in unacceptable discrepancies, I still have heard over the past couple, 2-3 years, time and again, that, the thing we're doing wrong here is we're not looking at, this particular person, there are circumstances. Did they get treatment? Did they get help on probation? Or have they been referred to treatment 10 times in the past? A rule like this allows the judge to do that. A judge might say, your number is so high, I'm not even going to give you another 3 months because it's just piling on. A judge might say, well, this new offense isn't all that bad, but you've been on probation for so long with so many opportunities, I think it's appropriate that you get an extra 30 days because you committed a new offense. So I think there's flexibility there, and it doesn't require it either. So I was trying to satisfy everyone, and that's why I put this forward, and I don't know what people think of it, but I just wanted to make one last good faith effort to come up with something that everyone could live with. In terms of, is this complex? I don't think it's complex. We already have a rule that talks about, an additional 3 months. We're just changing how we use it. We don't change how we define custody. We don't change how we calculate custody. And if we're going to apply it across the board to anybody with a 1/2 point for custody status, no matter where they are on the grill, it seems pretty simple. And then as I read the guidelines when it comes to sex offenders, there's no opportunity for a 1/2 point with them. So this doesn't impact any of those people. We could keep them separate as we have. So that's the pitch. I don't know what the procedure is. Do I move for adoption? Do we have some discussion? But I think this is worth considering. And if necessary, I would move to adopt this proposal instead of what went to the public hearing.
Are you making that motion now?
I make that motion now.
Okay, so we had.
I have a
motion.
point of order.
Commissioner Chanel.
Just a point of order here. I'm trying to make sure I understand. And I also want to be really clear about the fact that one of the things we did as a commission was look, I'm just going to be really bluntly honest here. one of the things that had come up after we did probation cap was the establishment of a series of rules. And those rules really governed kind of how we would bring about new issues that would be on the table for decision making. And I just want to be clear in terms of my view. And again, I'm grateful for and appreciate the effort to try and find alternative proposals, but I don't think the proposal comports with the rules that have been established by the commission in that rulemaking that was established post the discussion around probation cap. And just to be clear about what that is, I think certainly, there was one, kind of element that was the 7 days. I would argue that, that Commissioner Larkin's proposal didn't, meet that, the original one that was submitted with the packet. But ultimately, the other thing that was required was in order to engage a new kind of effort, there would need to be, that was not really previously discussed or listed as an item of action itself, that ultimately would require 2/3 vote of the commission to move that forward. And so I just want to raise this as a point of order because I don't believe that the proposal comports with that, and believe that the rules that were established by this commission that would require us to first act upon moving this issue forward, because it wasn't part of the previous discussion, would need to require a 2/3 vote of the commission to put on the agenda. And if I would stand corrected if I'm reading or recognizing the rules differently.
So Commissioner Schnell has raised a point of order. I've been considering this myself, and I pulled up the first reading rule, so I will read it out loud today. So the first reading rule says, a motion to modify the sentencing guidelines is out of order and therefore no action may be taken unless the members were notified at least 7 days before the meeting that such action might be taken at the meeting, and the commission has discussed the modifications or a similar or prior version of the proposal at a different commission meeting within the previous 2 regular meetings. So I think there's a couple issues here. I do think your original proposal came in at the 7-day mark. This one that you're talking about today came in last night, so it doesn't meet the 7 days. I'm also concerned that I don't think it meets the similar or prior version of the proposal piece of our rule. It is custody status, but it's a version of it that we've never talked about within the past two meetings. So I'm concerned about that, and for that reason, I don't think we can take action on your proposal today unless we do have a 2/3 vote to overturn the first reading rule.
May I respond on the point of order before you make your ruling as chair?
Commissioner Larkin.
Thank you. I appreciate the concerns that are raised, and I fully support compliance with the rule. But I think I would just say a couple of things for the commission's consideration. We've been talking about how to resolve the half-point rule for over 2 years. We've had 3 public hearings. We've had a work group. We had a public roundtable forum. We discussed several potential resolutions. Some resembled this in terms of an enhancement, in terms of taking it out of custody. We've been all over the board. This is hardly a situation where people are like, oh, I never could have imagined that this would be suggested. We've been talking about custody status for 3 years, 2 years, forever. So I think we should consider that context. I don't know that this proposal, quite frankly, isn't an appropriate change based on what we heard at the public hearing. I mean, people at the public hearing said, we don't like this rule. So is the option then, we just don't go for, we do nothing now? So I'm just trying to be practical here. I mean, we didn't really get support for what went to the public hearing. So I don't know if people are going to recommend that we adopt that without public support. It doesn't seem like a way to go here to me. So it seems that we should be talking about, and I know efforts have been made to generate conversations for some time about what we would do today if the public didn't support this new proposal. So I'm just trying to bring something to the table. I'm not trying to shirk the rules. If I really felt that this was something out of the blue that had never been touched on, when we had, however, many proposals we considered, we ranked both them down to 7, we knocked some out. It's like we've, I think, been all over the place. So I wasn't intending to violate any rule. I just wanted to say that and ask that it be considered in determining whether this was out of order. And I guess I would ask to hear from the chair on why this, you know, I remember when we had the public hearing on probation caps, it was supposed to be a firm cap. And then when we got to the meeting, same meeting as today, we were told, oh, we're not going to do it that way. It's going to be something permissive and that you need a Blakely trial. I mean, that to me seemed like a significant change in what we had presented at the meeting. And we were told, it's okay, it's close enough. We can consider that change. I don't know how this is much different given all the discussions we've had.
So a couple of responses there. Number one, we were, all of the changes that were made to the probation proposal came out of the public hearing. They were all things that people who testified at the public hearing suggested that we change. So every change that was in there was consistent with the testimony that we received. I'm not seeing that same consistency here in the proposal that you're giving us. And we had the AG's opinion to tell us that it was consistent as well. Here I have concerns. I have a question as to whether your proposal really does flow from what we heard at the public hearing. So I'm not saying that we couldn't ever consider it, because we certainly can, if we don't take action on any of the other proposals in front of us today. We definitely could continue to talk about this. There's nothing that precludes us from that. My concern is it feels like a big enough change that the public has not had a chance to react to it. So it would just mean that we would have to go through that procedure if that's the will of the commission. What I'm saying, I'm not saying we can't ever take action. What I'm saying is it does not seem like we could take action today unless 2/3 of the commission votes to overturn that rule to put it in an action stance today.
Madam Chair, there may be some online people who want to give you advice.
Yeah, I do want to move to them next. So thanks. I saw a hand up from Commissioner Estrada, and that's the hand I see up right now. I saw Commissioner Schnell raise his hand a moment ago, so we'll get back to him and see if he still wants to speak later. Commissioner Estrada.
Thank you, Madam Chair. I share the same concerns as yourself, as well as Commissioner Schnell. In hearing from the public, you know, they were very specific about it being the dispositional departure as the biggest concern of the proposal, not rejecting the proposal altogether. And we also heard from the Public Defender's Office about the language of custody. So I think that what staff have provided addresses and aligns with the AG's orders of saying we can adjust based on that public hearing. I share the concern that this new proposal is a brand new proposal. I also share concerns with the proposal itself. And though I know that we haven't talked about if we'll take action on it, but I would encourage everybody to pull up the drug offender grid. There is a claim that it does what this proposal does what the commission intended with the half custody point of getting a consequence, but I would argue that it doesn't. It actually increases sentences, as if people increases it. If we went back to everybody having a single full custody point, there's some areas where people would have higher sentences. So for example, if somebody is on supervision for a 5th-degree possession, and then they pick up a new 5th-degree possession, they would have 1 criminal history point for the case that they're on supervision for, and let's say it was 2018 before all of this changed and they had a full custody, it would be 2 criminal history points in calculating that sentence. And that sentence would be 12 months. Based on the new proposal, that 12 months with the two criminal history scores would be up to 15 months, which is a significant increase. It goes against what the intention was of the half custody point. It goes against what the intention was of previous commissions when they redid the entire drug grid to have, you know, more accurate and reasonable sentences. This is an increase in sentencing in our lowest level offenses. And that is not what the public was saying. The public's biggest concern was repeat violent offenses. That was the biggest concern. And it was said over and over again that people wouldn't mind that it's these low level offenses, it's the serious ones. And this proposal goes against everything that 2 commissions, past commissions, have worked on big projects where there were unanimous decisions. So not only do I share the concern about the process and the protocol and the order, but there's some real concerns that we are having higher sentences, potentially higher sentences on this new proposal, and the concern of may or may not. There's a lot of disparity that can happen within that.
Commissioner Knudsen?
Well, it sounds like, and now we're arguing the proposal, and I don't know that that's where we want to be at this time. I support this new amended modified proposal that we received yesterday. But I also have concerns as a public body for the procedure and whether or not we're following our rules. And I don't think we want to or need to get into a discussion about whether we've discussed these specific modifications before or similar or prior version of the proposal. You could argue either for or against, and both sides could be correct. But what I'd like to see us do is move intentionally forward after we have all had a chance to fully digest and understand the impact of this new amended proposal on all 3 of the grids. And incorporate possibly then some of the other things we discussed to lessen those any implications that would move those very low level crimes in across the threshold and requiring a commitment. So I think we again you know, we started out talking about a very simple concept of a 1/2 point. And the guidelines, because we want to take into consideration so many aspects of our sentencing philosophy, policy, and then the reality of any sentence, it's very detailed, and it's much more complex than simply talking about just a 1/2 point. And I think the commission has been very diligent, has done a very good job in studying all the different aspects and ways that we can handle a 1/2 point and what those implications are. And so I would really encourage us to not take action on the proposal that was submitted to the public, but to take those public comments and to consider this amended proposal that's been brought forth by Judge Larkin at our next meeting. This would give us time to really understand and address some of the concerns, make sure that it does exactly what we might think and hope that it does, make it more simple, not necessarily cause it the extra 3 months to move to a commitment on most on the boxes, and to address the concerns that have been raised by other commission members. So I would like to see this motion made, which it has been. I don't want to see us take action on it today because I want to get any further public comments, and I want all of the commission members to be able to fully digest what this proposal is and to make any further tweaks or recommendations to the substance of this amended proposal at our next meeting. Thank you.
All right, well, I am ruling the motion out of order. I don't think that the proposal is ripe for consideration today.
Madam Chair, I'll
Commissioner
withdraw
Larkin.
the motion.
I'll withdraw the motion. All right. In order to take it up, we would have to have that 2/3 vote to suspend that rule. All right, any further action on the custody status issue today?
Well,
Commissioner Larkin.
I would move consistent with Commissioner Knutson's statement that the commission reject the proposal that went to public hearing, and then we continue to explore ways to resolve the custody point issue, starting with this proposal. I'd also note that in my communications with the executive director, he had some sound ideas about ways to do it that required too much tweaking for me to raise today. So I do think there are some other options we could consider. But I think we need to commit to, doing that in January and February, and then being done with this until we get to the public hearing in the fall, or in the summer, I suppose. Not sure how the scheduling works. So that's my motion, to reject the proposal that went to the public hearing and commit to studying other proposals, including the one I've set forth and anything we might get from the executive director.
All right, so we have a motion. Do we have a second? Commissioner
I
Schnell.
second that.
All right,
I
we
would
have a
second it.
motion. Motion and a second. Do we have any discussion? Commissioner Middlebrook?
Thank you, Madam Chair. I guess my concern, I didn't weigh in on the earlier points, but there's no need to. But I guess my concern is right now, the meeting before this went to the public hearing, we all, there was a lot of discussion about this needed to be resolved. And there, we had asked, I think there was even a proposal that we incorporate the custody status into a review of the whole guidelines. And that was, my understanding, voted down. Can't remember exactly how that worked, but there was a big concern about everybody needing this to be resolved rather than continuing on looking at it. And now today we're changing our mind again to prolong this. I guess I'm just concerned that, it's going to be another year before we have any decision on this. And there's a lot of other things that we need to do and we can look at with the other policies and parts of the guidelines. So I guess I'm concerned about that it's, again, not going to be resolved. For the practitioners, for the courts, we won't have a resolution.
Commissioner Schnell and then Commissioner Hansi.
I appreciate that comment, and I guess I'm wondering if we reject the proposal that went to public hearing, I would presume what is going to be practice continuing would be the existing Court of Appeals decision. Is that a fair assessment? I'm asking the experts here.
I would assume so, yes.
Okay.
Everyone's nodding their head in this room.
Without claiming to be an expert.
Commissioner
So I guess
Hansi,
that
and then-
the only,
go ahead.
I asked that question, I asked the question only because I guess it is to Commissioner Middlebrook's kind of proposition or the point she's raising. Is there something that you would see as an interim measure that would comport with everything that we would need to do, or is Bogdanovich that decision really just the best we can do given where we are?
Commissioner Middlebrook, I think he's asking
Thank you,
you.
Madam Chair. Yeah, I mean, I guess if that's going to be this, basically the status quo, I guess I'm just going back to the meeting where everyone was, pretty adamant that they wanted this to be resolved rather than to continue on with other ideas. But, obviously if that's the status quo right now, I think there was also the question on the 3 points being added to at the end of the 3 months added to the end of the grid, that was a little bit up in the air. But if, Bogdanovich is the current state of the law, then that would be where we'd be until anything else is resolved.
Commissioner Hansi and then Commissioner Lett.
Thank you. I just want to raise my concerns for continuing to push this issue out. It has been, I remember it's been over a year and a half when we had said in last November in 2021, we were going to be making a decision. Here we are now in January of 2023, and we're being asked to continue to push this out. And now I believe Commissioner Larkin said until public hearing again in the summer. I feel like we have a duty and a responsibility to get work done while we're here, not continue to push it out. And it feels like that it's just a continued scramble to try to come up with something. And I don't know if this is just being done because somebody wants to be right. Somebody wants to get some sort of I don't understand what the issue is here, that we have to continue to push this out for over 2 years and now it'll be coming up 3 years that we can't make a decision and move forward with making the changes that need to happen. That's my concerns.
Commissioner Lett.
Thank you, Madam Chair. I guess I agree that we've been dealing with this for quite some time. In fact, my whole entire tenure since I've been on this commission this has been the issue that we've been dealing with. And so I appreciate the folks who were on the commission that when this half custody status point thing occurred and the issue was illuminated to us, and now we're here trying to address it. My biggest concern is, and I think we should learn from what's happened before, is we ought not to just make a decision so that we can move on and do something else. I think we can walk and chew gum. So I think we can work on this and we can work on some other things. And I think there's some important work for this commission to be working on. And I hope that we can continue to do that. But I think what we should all be focused on is getting it right and not just passing something just to be done with it. And to Judge Knutsen's point, on its face, the custody status point seems like a sort of a benign issue, but there are a lot of tentacles to it. And there's a lot of policy considerations, and we all have different sort of views on those policy considerations. I recognize that, and I appreciate the robust conversations around that. And as much as I want to be done with this particular issue so that we can move on, I want to get it right. I don't need to be right. I just want to get it right. And I feel like right now where it sits, there are too many things that I feel like doesn't make it settled enough for me to say that I could support as it currently sits. And so I want to work with everybody on this issue to get it right, but I just feel like we're not there, and it's frustrating. I know, but I feel like the prudent thing for all of us is to make sure that whatever we do, whether it's at a later meeting and it delays it, we just got to get it right. And so I share the concerns about sort of where we're at and why we're here, but we do have an obligation to get it right, and I feel like we're not there yet.
I came prepared to vote to get a proposal through today. I really did. And I am frustrated beyond belief that, I'll be honest, Judge Larkin, this is the third time that you have caused the delay on this issue. And we are going into our third year because you have caused this delay. And I'm not going to sugarcoat it. Like, this is what's happened every single time.
How so every single time?
Every single time, right, the week before we were going into a final vote, you came up with a reason why it wasn't going to work. And we weren't able to vote on it. I can only imagine how frustrated the public is that we are not resolving this issue. I really did come here today prepared to vote on one of the proposals that we had in our packet. I think everybody here came prepared to vote on something. And I just, hope that we can follow the procedures that we have put in place. I haven't put anything on the table in an inappropriate time or manner. And I've been working with the, proposals that have been put out there. Like we have to do this right. And this is not furthering our agenda to continue to push this out. I'm going to take chair's privilege and tell you what's wrong with your proposal too. I am. I'm just going to tell you that right now. Number one, the way that you have it worded right now, it says you have it in a provision that says presumptive sentence. It's not about what the judge's decision is. It's about what the guidelines say the presumptive sentence is. And you've made that a may. So now we don't, under this version, nobody will know what the presumptive sentence is. Because the judge will have to decide, does the range change? And then within that, what am I going to impose? It's not how you write the guidelines. It's not how you write them. This is completely an inappropriate approach. It's not going to work. I'm not saying, I'm not even taking into account whether it's a good proposal or not. The language itself just doesn't work with the way that our guidelines are written. But if you keep coming up with things the night before the vote, then that's the kind of language we're going to get. So that's why we're in this position.
Madam Chair,
Commissioner Larkin.
I just am frustrated because, honest to goodness, with the exception of the proposal to eliminate custody points entirely, I don't think anyone in this room has presented a proposal except me. And we're not allowed to have meetings outside of this context. And I apologize. I'm constantly thinking about it. I'm bouncing it off colleagues. I'm suggesting things. I said when we voted to take the last one to a public, I don't think it's the best proposal. But the problem is I'm the only one bringing proposals. And then we don't really have a forum where we can talk about them and hammer them out. Instead, I just get another personal attack. Like, here I am bringing another proposal and I don't know how to write guidelines and I don't know what I'm doing. I'd love some help, but this is what I'm doing. I'm doing it by myself at this point, and I feel like I have been for some time. I'm not trying to trip people up. I'm not trying to delay. I am simply trying to get to the best solution.
And I'm not
I take
disagreeing.
offense to the personal attack.
I'm not disagreeing with.
Who else
the
has
fact
brought a proposal to the table? When you said, please bring proposals to the table after the public roundtable. It doesn't have to be in writing. It doesn't have to be fancy. Just come in and give us your ideas. Who gave you ideas?
We had a month. We had more than a month between the public hearing and this meeting today. There's no
Madam Chair,
reason
it's
for
my
proposal to come in the night before.
Okay. It's my understanding that a request was made to reconvene the work group on the half point issue after the November meeting, so that there might be some forum to discuss these things and try to come up with another solution. And there was no reception.
Yes, you
to
did
that.
make that request, not directly, but you did make that request to me, and it was totally inappropriate because by then we already had a proposal that was going to the public hearing. So I was following the procedure of this commission, which has us vote in November, send the idea to the public hearing, hear from the public. If there are tweaks that need to be made from the public input, they get made. Director Wrights actually made, I was going to make the same change that Director Wrights made, and he wrote it up before I had a chance to. So I didn't have to write a proposal, but mine would have been Appendix 2 in the materials that we got today. It would have been equivalent to that. But that's the procedure. Had you followed that, there wouldn't have been any issue today. Commissioner Estrada.
Thank you, Madam Chair. I share the frustration as well that we're we're continuing this when the rhetoric the last time was, we can't keep pushing this out. There's a lot of rhetoric of we can't have the appellate court be making policy and governing this, and we have to do something, and we have to do something, and we put something forward. I think the fact that we got public input and it was, certain public input says something. To me, it says that we were closer, right? And then this meeting is to be able to tweak it. And I did come here today prepared to vote, and I also support Appendix 2 of the information that was sent out today, because it does relate to the public input that was given to the proposal that was presented. And I share that frustration as well. But that's where I am, is I would like for us to continue. I would like for us to take action on this. And the fact that we had a public hearing and what we heard is addressed in the new proposals that were presented and that I would support, says something.
Madam Chair, I don't know that there's a second to my motion. Perhaps we should.
There was a second.
Commissioner Schnell
Oh,
seconded it, I believe.
Any further comments before we take a vote? Commissioner Schnell? Commissioner Schnell?
Madam Chair, I was just going to say I would call the question.
Yep. All right, we'll take a vote.
To the Larkin motion to reject the proposed changes to the calculation of the custody status point considered at the December 15th, 2022 public hearing. Estrada?
No.
Estrada, no. Hansi?
No.
Hansi, no. Ibrahim?
Yes.
Ibrahim, yes. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
yes.
Larkin, yes. Middlebrook?
No.
Middlebrook, no. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes.
Yeah.
Chair Mitchell?
No.
Chair Mitchell, no. Madam Chair, there are 7 votes in favor, 4 votes opposed.
And with that, the motion is approved. So we will not have a custody status proposal in our final report. We will not be sending that to the legislature this year. The next item on the agenda is modifications related to sex trafficking. I would entertain a motion. I think I can easily say that I would entertain a motion to approve those modifications. Commissioner Morath makes that motion. Do we have a second?
Second.
Commissioner Larkin seconds. Any discussion? Hearing none. Take the vote when you're ready, Director Wrights.
Thank you, Madam Chair. To the Morath motion to adopt the proposed changes to adopt the proposed modifications related to sex trafficking considered at the December 15th, 2022 public hearing. Estrada?
Yes.
Estrada, yes. Hansi?
Yes.
Hansi, yes. Ibrahim?
Yes.
Ibrahim, yes. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
With that, it's approved unanimously. Next item is approval of the technical modifications that went to a public hearing. I would entertain a motion to adopt those.
So moved.
Commissioner Larkin makes that motion. Do we have a second?
I'll second.
Second.
Commissioner Ladd seconds. Any discussion on the motion? Hearing none, you could take that.
To the motion to adopt the proposed technical modifications considered at the December 15th, 2022 public hearing. Estrada?
Yes.
Estrada, yes. Hansi?
Yes.
Did I hear a yes? Yes.
I'm not sure.
I heard yes.
Hansi,
Yes.
yes. Yes. Ibrahim?
Yes.
Ibrahim, yes. Knudsen? Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
Okay, with that, the motion is approved unanimously. So items B and C will be included in the report to the legislature. The next item on, we will have, we're going to have to talk about how we're going to put the custody status point piece in the report, as I assume that you will retain the fact that we had discussions in the report. So let's move on to item 6, which is review and approve the 2023 report to the legislature. Executive Director Wright.
Thank you, Madam Chair. So, yeah, that's an excellent point. So I'm going to walk us through the report to the legislature. I'm not sharing my screen yet. There we go. So I guess the first question has to do with the second page, the page where the commission members are listed. I received notice this morning that Commissioner Hansi intends to resign effective tomorrow. So I'm not sure whether to, I guess if it's all the same with you, we could just leave her name here and maybe make an asterisk after the page that talks about.
Yeah, I would just put an asterisk next to her name and drop it on the bottom and put her resignation, resigned as of 1/13 or something like that.
Yeah, I mean, I don't know. Most of the asterisks are on the other page, but.
Madam Chair,
Commissioner Knudsen.
I don't know why we have to do that. I would just leave it as is. She's been a longtime member and has been and served up until the point this report was prepared and submitted to the legislature. So I don't know that it's necessary that there be an asterisk.
I would support that as well,
Okay.
actually.
All right, so moving on then to page 1 of the introduction. So we did get the Bureau of Justice statistics after the last meeting, and they dropped us or raised us, depending on your point of view, to 6th lowest imprisonment rate in the nation, and revised the numbers from last year to also indicate that we were 6th lowest. So that's new. Minnesota has never been the 6th lowest state as far as the imprisonment rates rankings go in the history of the sentencing guidelines. For the most part, it's been the first, second, or third. It was the 4th lowest in a few years in the 2010s, and the 5th lowest in 2017. So this is kind of entering new territory as far as that goes. And it's not because if you look at the chart here, you see that it's not that Minnesota's imprisonment rate has gone up. It's rather that that slope from 2020 to 2021 is going down, but it's not as steep as the all-state slope. So that is going up. I did include the U.S. violent crime rate and the Minnesota violent crime rate. It's not the only crime rate I could have chosen. I did pick that one because it had the same axis, which is rate per 100,000 residents. And if that's satisfactory, I'll just keep that on there. But that is new, having the U.S. and the Minnesota violent crime rates. Honestly, looking at that, I don't know what conclusions can be drawn, but I'm happy to keep that on there if that's the will of the commission. Moving on, and I'll just keep rolling unless there are any. We did add the agency rulemaking docket pursuant to your vote last meeting. And Commissioner Knudsen, I guess my suggestion here would just be to keep this page the same, but just put an asterisk after Tanya Hansi and just say Commissioner Hansi submitted her resignation effective January 13th, which would be the date of the report.
I don't know if it
So,
matters. Under my name, I'm no longer with Eden Prairie. I'm with a different department.
Okay, so you are. I'm getting echo on your line. So you're no longer with Eden Prairie?
Yep, I'm with the city of Minneapolis now.
Okay, so just change Eden Prairie to Minneapolis. Is that correct, officer?
Yes, sir.
Okay. All right, so we will make that change. Thank you for that. So I guess I hadn't really thought about this. Perhaps I should have anticipated it, but I did not. So let me just think.
I mean, maybe you just on the line that says January 13th, you say, after considering the public hearing, the commission chose not to adopt the proposal and will continue working on it in 2023, and then take out how the change solves the problem. Something like
Works
that.
for me. I'm not hearing any objection to that, so I guess we'll do that.
I think that's good.
Okay. All right, and then we have no changes to the sex trafficking other than the unanimous vote today. So no changes, no real changes there. Other work, just looking for. All right, we do have proposed changes to the commentary that were voted on last month. Changes to the sentencing guidelines, rulemaking docket, all that was discussed last month. That's why it's in yellow. A few typos on the staff section. We're referencing the wrong year. I did clarify that to felony case volume and distribution. So the big new chart here is so this is figure 6. So figure 6, we made a change where we had previously just had the distribution of cases by judicial district, and there was a table underneath. So what we've done is we've gotten rid of the table because it was just too much information for a table, and we added each district's racial distribution of cases, and then their racial distribution of population. And I did misspeak at our last meeting. I don't have access to countywide data by race, by 18 and older. I don't have that information. I do have basically people broken up by 5-year age groups, by race, by county. So what I've done here is just included residential population age 15 and older, recognizing that that's not entirely the population that's at risk to be in the felony pool. But it seemed like either way, you're going to be under-inclusive or over-inclusive. If you cut it off at 20, you're missing out on 18 and 19-year-olds. It's probably not that much different either way. I think it kind of gives you an idea of what the population chart looks like versus the felony case chart in either event. Is there any comment about figure 6? Any suggestions to do it differently? All right, and then the other one I'll assume silence is consent. The other figure that we changed here was this pie chart here, figure 12. So we did break out a number of the different dispositions with respect to this new type of departure, the probation cap departure. They all fit within this little other slice, this 4.4 slice. So there's the other slice, and then it's broken out here in this bar chart. So this bar chart is equal to that little slice. And you can see in there the blow up of the aggravated disposition, which is almost no cases, the aggravated duration, which is 1.3% of all cases. Then you've got the aggravated probation cap by itself, and then mixed with the mitigated dispositional departure. And you got mitigated dispositional departures mixed with mitigated durational departures, and mitigated dispositions mixed with aggravated duration. So it gives you a little more detail there on the total departure rates. Not hearing any comments there, I'm going to keep going. I think that was mostly it for the changes. Then we just get to the county attorney's report. We did have quite a few counties respond. As of earlier today, we were only missing Todd and Douglas counties. And if I get those counties in by the end of, well, if they're in my inbox tomorrow morning, they'll be in the report to the legislature. So, or the sentencing guidelines report. So I think it is interesting to look at figure 22. So this is with the actual data plugged in. It wasn't plugged in last time. So you can see that it's interesting that the county attorneys reported more of the by percentage by the prosecutor versus by the court, where the mandatory minimum was waived, where it applied. This year, the county attorneys report that most of those were waived by the prosecutor, which is not what we saw last year. And we haven't always had this little fork here where we disclose whether the mandatory minimum was waived by the prosecutor, by the court. That was something we initiated after a comment from a legislator, I believe, who wanted to know that information. We do collect that data, so we do report it this year, or last year, and now this year. So, but county attorneys are reporting that most of the mandatory minimum were imposed and executed when they applied. And we do have a footnote that has sentencing guidelines data in footnote 40, which doesn't entirely line up with the county attorney's data, but it's also a different year, so it's hard to compare. So I think that's really it for obviously we'll make changes to the appendices. There won't be an appendix 1.1, but we'll make the corrections in the other appendices. So, Madam Chair, I guess subject to the, with the understanding that a motion to adopt this report would include the oral modifications that we've just discussed, and would also authorize staff to make appropriate, to exercise some degree of judgment in making appropriate editorial changes. I would ask for the commission to adopt this as its report to the legislature, and that'll be sent out to the legislature tomorrow.
So I'd entertain a motion along the lines of what Director Wrights just said, to approve the report with the changes that we made orally here, as well as giving him discretion to make small editorial changes as he deems appropriate.
So moved.
Commissioner Moore makes that motion. Commissioner Middlebrook seconds. Any discussion on the motion? All right, hearing no discussion, go ahead and take the roll.
To the Moore motion to adopt the 2023 report to the legislature, subject to the comments made within the meeting. Estrada?
Yes.
Estrada, yes. Hansi?
Yes.
Hansi, yes. Ibrahim?
Yes.
Ibrahim Knudsen?
Yes.
Ibrahim, yes. I think that was Knudsen, yes. So just to back up, it's Hansi, yes. Ibrahim, yes. Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
All right, with that, the motion is approved unanimously. All right, so we're down to item 7, which is the Executive Director's report.
Thank you, Madam Chair. I do have 5 items to report to you this month. The first is that you should have gotten in the mail Campaign Finance Board statements of economic interest for public officials. Those are due to the Campaign Finance Board by the end of the month. It's mandatory for all members, even outgoing members, Commissioner Hansi, so you do have to do that. If you haven't gotten a letter in the mail, please contact the Campaign Finance Board. Second, just an update on the Secretary of State application status. As of yesterday, I'm going to just go down each position. For the public defender position, there were 2 applicants, including the incumbent. For the county attorney, there was 1 applicant, that was the incumbent. For peace officer, now there were 2 applicants listed on the Secretary of State's website, including the incumbent, but those are both left over from the 2022 vacancy. So Officer Ibrahim, I'm not sure if the Secretary of State's going to count those as being applicants for your position or if you need to reapply. I would suspect you'd probably be best off reapplying. So at this point, nobody's applied for that position recently. Probation or parole officer, there were 4 applicants. The incumbent is not among them. For the public member general, there are 2 seats. There were 13 applicants for those seats. 1 of the incumbents reapplied, the chair. The other incumbent has not reapplied. And as we've just found out, she's announced her resignation effective tomorrow. I do thank you for your service, Commissioner Hansi. Public member felony crime victim, there are 2 applicants, including the incumbent. My third report has to do, and I should just inform you all that everybody continues to serve until your successor is appointed or until you resign. But please keep coming to these meetings. Thank you. Budget request updates. The governor's new corrections policy advisor was installed just last week and talked to me this morning about the change requests. The budget is due, the governor's budget is due to the legislature in less than 2 weeks. And so I don't know how our change requests are going to do. I'm not in the room. Commissioner Schnell is in the room. Commissioner Schnell, if you're still on the line, I hope you'll put in a good word for us. Thank you very much, sir. The fourth item is legislative update. I was invited to testify briefly before the House Public Safety Committee on Tuesday, which is chaired by Representative Kelly Moeller this session. And I mentioned your legislative recommendations to them. They did ask about that. So that was the only part of the report to the legislature. I kind of gave them a preview of, well, some of the data too. But one of them is already an author's amendment on House File 42. And I didn't listen to the hearing this morning to know whether that author's amendment was actually added to House File 42, but it has to do with the definition of some of the terms for aggravated sex trafficking. So you're already making an impact. And the final thing that I have the displeasure of announcing is that 39 years ago next week, while still in graduate school, Ann Wall began working in the Minnesota Health Department. A few years later, she began working full-time as a research analyst at a young state agency called the Minnesota Sentencing Guidelines Commission. Sadly for us, but happily for Ann, we've learned that she will not make it to 40 years as an active state employee. She will be retiring in July. In fact, she has already partially begun her retirement, having entered into a 6-month phased retirement program where she gets to enjoy some extra time off. But we'll all get to enjoy her expertise on a half-time basis. I'm sure we'll recognize her further as her retirement date approaches, Madam Chair, but I wanted to alert the commission to this momentous milestone on the way. Ann has really been the historical memory of this commission for a lot longer than I've been on it. Thank you, Madam Chair. That concludes my report.
Thank you. Well, I just want to, I know that we will recognize Ann eventually. I want to say that's a bit of a devastating blow. I had the pleasure of being her supervisor when I was the director of the commission, and I can attest to the fact that she is the sort of heart and soul and institutional knowledge of this place, though Jill is trying to take her place by coming up right behind her. So that's going to be a huge change for the commission, and I'm looking forward to the opportunity to recognize her service. I also was very surprised today to hear that Commissioner Hansi was resigning from the commission as well, and so it gives us no time to recognize her service like we normally would. Of course, she'll get the plaque, like everybody gets the plaque, I think, or at least some sort of recognition. But Commissioner Hansi, I just want to say it's been a real pleasure to work with you on this commission, and sorry to see you go, but I really appreciate the voice that you've given, especially to people who've been convicted of criminal offenses in Minnesota, and just in general, you're really bring a lot of knowledge to the table, and I've enjoyed working with you. So I just want to recognize your service as well. Oh, you're muted if you wanted to say anything.
Thank you so much. And I also want to just say that it's been an honor and a joy to the last 4 years work with the commission, and to be able to push through some big work that has meant a lot and has done a lot of change within the community and for people who have experienced the justice system as I have myself. And my hope is my successor will also be someone who has been directly impacted by incarceration or the justice system, to be able to continue to give voice to that. So thank you all so much.
Thank you. I feel like I missed Commissioner Knudsen. Did I miss you? I feel like I started talking over you.
Oh, I just was going to comment, with these resignations and whatnot, and then retiring, with Ann retiring, Madam Chair, don't you have some authority to either accept or reject these resignations?
I wish. That would be awesome. All right. Well, I think it's time to move on to public input. I think that's the last item on our agenda today.
All right. And does Commissioner Schnell actually have his hand up, Madam Chair? Or
I don't think
that left
so. Commissioner Schnell, your hand is up, but did you mean it to be up?
Apparently not.
No. Okay.
No, I'm sorry.
That's all right.
Madam Chair, at this point, I'd like to address the members of the public listening in. If you do want to make a comment, please raise your hand. There should be a mechanism for raising your hand. If you're unable to raise your hand, I do see one hand raised. If you're unable to raise your hand, please call our office at 651-296-0144. All right, and I'm going to unmute the first person who's identified here is Jacqueline Williams. All right, you're unmuted, Jacqueline Williams.
Please go ahead. We're not hearing you. Are you, Jacqueline Williams, are you ready to speak with the commission?
Hand just popped up.
Does she have to put anything on her end?
Yeah, it's possible that she's speaking from a device that's muted. I don't know. As far as WebEx is concerned, she's unmuted. I could try making her a panelist and see if that helps.
Sure.
All right. Jacqueline Williams, are you there?
No, I don't see any.
Yeah, I don't see the hand up either.
She's gone.
Okay.
All right.
All right, so I'm going to unmute a call-in user, phone number starting with 612-224. Just because I don't think you can raise your hand. All right, I've
you hear me?
unmuted you, call-in user. Do you wish to make a statement?
Yes, can you hear me?
Yes. If you could state your
Yes.
name, please.
This is Jacqueline Williams. I just want to say I was once again kicked off the webinar. I don't know what's up with that, but anyway, had dialed in to make sure I could comment. So on the custody status point issue, I believe this issue started maybe in the fall of 2021, maybe earlier. There was a frenzy. Some far right group said, eliminating half custody status points for low level offenses, and the public really got involved, right? And so that was sort of like an initial complaint if you were going to file something with the court. Judge Larkin's proposal today is so close to that initial complaint. There's little room for breath between that complaint and her proposal. If you want to tweak that proposal, don't say potential, say must. Say must have an additional 3 months. Chair Mitchell, you're right, the public is disappointed, but not with Judge Larkin. Really with you, Chair Mitchell, and other members who don't support public safety. Judge Larkin is not the cause of delay. She is the only one, and others support her, who has been working on this. One of the commissioners commented that the public was not concerned about the prior dispositional durational departure. Well, I think the only person I heard talk about that at the December 15th hearing was MACAC, the person from MACAC. And I'll just say from this public, me, we don't care if an additional three months bumps someone up into a presumptive sentence. We want to see people who offend while in custody to have a consequence. And I don't think most of the commission members understand that. That's your primary goal and purpose. And I am so disappointed. I had hopes today. I hadn't had a chance to look at Judge Larkin's proposal, but I did look at the proposal by the staff. I looked at Appendix 1, and I thought that was simple, clear, addressed the public's concern. It felt like you had listened to the public, and I put this on you, Chair Mitchell. It's like you're not listening to the public. I have to say that. You want to make a personal attack on Judge Larkin. Well, look what you're doing to all of us out here who are living with this crime. And so I had great hopes for a vote today. I was hoping for a vote on one of the appendix. I didn't really focus on Appendix 2, but I loved Appendix 1. And so the only reason this keeps getting pushed out is because a majority of members don't want to focus on public safety. They don't want people to go to jail. Some people need to go to jail. There need to be consequences. It has to stop. This is your purpose. So thank you for all the hard work. I guess we'll continue it and we'll follow it. We'll continue following, but we aren't going to stop listening to you just because some of you stopped listening to us. So thank you very much.
All right, thank you for your comments today. Is there anyone else who'd like to make a comment today?
No one else has a hand raised, Madam Chair.
All right. All right, seeing nothing else on the agenda, and the commission is adjourned, and we will meet again next month. Thank you.